Determining actual ownership of bank accounts after the death of a loved one can really be challenging. There can be differences in what the parties to the accounts or the beneficiaries of a trust and the heirs of an estate believe and what they want. It's difficult at times to find a blueprint in which to operate. A 2017 California Court of Appeal decision, Higgins v. Higgins, helps to identify some basic guideposts for ownership determination. The case arose from a lawsuit brought by the personal representative of an estate against a wife who agreed to hold funds in trust for her husband's stepmother. After her husband's death, she changed the form of the accounts and used the funds for her own purposes. The appellate court concluded that the wife held the funds in the accounts in trust for the stepmother, and the transfer of the accounts into her own name and use was a wrongful act supporting the imposition of a constructive trust. It's not unusual that parties to bank accounts have a finders keepers approach to ownership of the accounts at the death of the account's co-holder. The parties to an account have a present right to payment in proportion to their contributions unless there is clear and convincing evidence of a different intent. So this can be a real stumbling block in elder financial abuse cases where there are disputes over whether an elder really intended to gift account proceeds during her lifetime. The Higgins case makes clear that other than joint accounts, taught in trust and POD or paid on death accounts, the death of any party to a multi-party account has no effect on beneficial ownership of the account other than to transfer the rights of the decedent as part of the decedent's estate. In other words, don't just assume that a party to a multi-party account receives all funds at the death of the other party. Such assumptions may lead to actions that result in litigation. Like anything, facts and circumstances differ in the conclusions that can be drawn are dependent on the particular facts of each case. At Hackard Law, we regularly represent clients in estate and trust litigation throughout California, whether that's in Sacramento or Los Angeles, Alameda, San Jose, or San Diego. You can reach us at 916-313-3030, and we'll be happy to talk with you. Thank you.